Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you for the introduction, Michael. Well, welcome to the show, Donald.
Thank you so much, Jim.
So I'm glad you're coming on for our monthly update here.
Glad to be here.
Let's tell the viewers just briefly about yourself if they haven't heard about you or seen us on the show.
Okay, I've been in town for over 30 years. I am an owner at Downing Fry Realty, been the attorney for 20-odd years. I own Ross Title and Escrow. We're on the corner of 6th Avenue North and 41. We have approximately 8 people. 4 main closes. My office manager's been with me over 30 years. And law firm as well. We do quite a few closings, work closely with the realtors, and enjoy coming on your show.
Yeah, you do a fine job for our customers, I know that.
Thank you.
So, Don, you know, we've just come out with new contracts in 2019, but obviously we've had the contracts for a number of years. How is the best way to sit down and explain from your viewpoint the contracts, because they are 12 pages long plus with all the addendums? So I know you work with a lot of for sale by owners, in that maybe we could go back and forth a little bit how I explain it. How do you explain it a little bit?
I try to get the parties in my office. We get people from different parts of the country, different parts of the world. So if you get them around the conference table, the buyers, the sellers, it's more easy for me to gauge whether they understand my explanation. I like to be able to look the person in the eye and see whether they understand my explanation, because sometimes I may get too legalish. They may have questions. So, and having both parties there, say you have two, husband and wife and a husband and wife, it gives them an opportunity to all be on the same page, to hear the same words coming out of my mouth at the same time, to be less miscommunication, and it allows me to pick my spots on how much information I'm going to give them. As you indicated, it's 12 pages, just the contract, never mind the 74 addenda and amendments and so on and so forth. So I tend to wing it a little bit, but there's 4, 5, 6 points I hit on. I'm very aware that people have a limited ability to absorb and retain information. I mean, I do. And where is that point? And you can kind of tell by looking at them if you've reached the saturation level of new information. And I hit them with the high points, and many cases recommend, well, take it home. If they have an unresolved issue, take it home, read it. I guarantee you're going to have more questions. Call me on my cell phone, I'll answer them. And I do that at least once a week. I've done it 2, 3 times this week, and I don't charge for it.
Yeah, what we normally do is we try and send them a contract prior.
That's
if
good.
we're listing or selling, because obviously you don't get, in our viewpoint or our way we handle it, we can't get the buyer and seller together and sit them in a room. That's we used to do that years ago. You're doing
the good old days,
but we don't do that now. So, and I always, when we have a listing, we always sit there and meet with them when we're doing the listing, or if we're representing a buyer. We try, if they're in town, we'd like to explain it to them in person. Rather, because today it's technology, everybody's emailing and stuff, and it's just not, the contracts are written by attorneys, basically.
Yeah, they are written by attorneys, and I really don't like doing it by email, because they can't tell if you're kidding. You can't tell if they understand your explanation. There's no substitute for just looking at the person and say, here are the basics, most important, most frequently occurring issues I see that I want you to get, and then read it. And if you have any further questions, ask me. If you forgot what I just told you, ask me. I work for you. It's okay, ask me.
So if you're sitting down with a buyer, what are those key points that you would try and cover?
Well, with the NABOR contract, I start with the property that's being conveyed, the first 13 or so lines of the contract, because that is radically different than what we have in the statewide contract. You got home entertainment systems and all sorts of, landscaping is now defined. So I want to make sure that, this is what you're buying, and you can, if you're buying furniture, how do you do it?
That's right.
If you have a short list of what you're buying, you attach that list. If you have a short list of what you're excluding, you attach that.
That's right.
So I start with that, and then I go to paragraph 1, which is the purchase price and the deposit and whether you have a mortgage and the net to close. The deposit, I usually have to explain to people what its role is. And the role is, this is the seller's only remedy against the buyer if the buyer, without legal excuse, walks away from the deal. This is all the buyer will lose. This is all the seller will get. So that's the function. Because many states, they do minimal deposits. It might be $1,000. I mean,
Right.
Georgia, for example, they do. My son's an attorney up there. And it's just minimal. And they get a little confused when you ask for 10% down here.
Right.
And when the contract gets to be a little larger, if it's, $2, $3, $4, $5 million, then you can, ratchet it down to, 5% or less.
Right.
It's enough to keep the buyer engaged, committed to the deal, and it's enough to compensate the seller if the buyer decides to walk away from the contract for no legal justified reason. So that's the second point, because I always get that. Well,
Right.
back home, it's always 1,000. Well,
Exactly.
this is the role.
This is the role.
This is
right.
the role.
And we usually do 2 deposits. One when we present the contract. We like to present it with a
Right.
deposit rather than 3 days later or after its effective date.
Right.
And we also try and do a second deposit after the inspection period too. Is that how you do it?
Well, if I'm representing the buyer,
Right,
yes.
that's
If I'm
right.
representing the seller, I
No.
say, watch out for that second deposit.
Exactly right.
Because what you get is, we're not putting the second deposit down until you agree to fix this, that, and the next thing. And it might be something that's cosmetic. It might be something that's not even covered by the contract. We want this, or I'm not putting down my
Right.
additional 9%. I mean, if the buyer only has $1,000 down, and it's $1 million property, they'll walk before
Exactly.
they put another $99,000 down.
So what's the next thing that maybe you go through here?
Well, if they're getting a loan, I go through the financing contingency, which is paragraph 4. And paragraph 4 was modified slightly with the most recent changes,
Right.
where there's now blocks to check on what kind of mortgage you're getting. And if you don't check the blocks, it's a conventional mortgage. It's not VA, FHA. It'll be conventional. So all the more reason for people to check off exactly which kind of mortgage they're getting and what the interest rate is. So when I get the financing contingency, I say the point of this is to protect the buyer's deposit.
Right.
That's the sole function. So you're doing the buyer a disservice if you don't put the interest rate down that the buyer can afford in that financing contingency. And then there's a lot of confusion over what happens after you get past the default waiver period, which is 45 days.
Right.
How much time does the buyer have to waive the financing contingency so that the seller can't terminate the contract and sell it to somebody else? And the way I explain, what the buyer does or does not have to do after the 45 days, assuming that's what it is I don't know your personal financial situation, Mr. Buyer. I don't know how much money you have in the bank. I don't know if you can afford to lose this deposit. But essentially what you're doing is you're weighing, gee, do I want to run the risk of losing my deposit if I waive the financing contingency, or run the risk of losing this purchase if I don't waive it?
Right.
Only you know your own risk tolerance. Only you know how much money you have in the bank. Only you know if you have enough cash to come in and buy it for cash if the bank, for some reason or another, has a problem with lending you the money,
Right.
which happens.
It does happen.
Depending upon the lender and whether they're out of state or not, you may find that their underwriting department is a little late in letting them know that the property doesn't qualify, or they don't qualify, or they're not comfortable with it and they just don't know the market down here, and they might turn down the application late in the process. I mean, a lot of folks just think, well, I make a lot of money and I have money in the bank, so it'll be no big deal. Not with the rules and regulations we have with the federal government now.
No.
It's a whole different ballgame. So that deposit versus transaction weighing, I find is beneficial. I usually, when I talk to the realtors, I say, it's the buyer's choice whether they waive. It's not your choice. You don't know what the person makes. You don't know what they have in the bank. Let them make the business decision of which risk they wish to incur, because either way there's a risk. You're either going to lose the deal or you're going to lose the deposit. And then the tail end of that paragraph talks about how the seller or buyer can terminate. And the buyer can only terminate if they have a letter of adverse determination, a letter from the bank saying we're turning you down because of something relating to the property. It doesn't appraise, insufficient reserves, whatever it might be, or you personally don't qualify. You might have insufficient income, excessive debt load, that you have little blocks they check off. So the buyer needs that. Buyer needs to make a good faith effort. The seller can terminate and sell it to somebody else if the buyer doesn't waive.
Right.
So I hit that when there's a financing contingency.
Okay, well, we're going to take a little short break,
Sure.
okay? And we're going to be right back, and we're going to talk a little bit about the York Real Estate Group and our commercial.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Well, Don, let's take the next one, which would be inspections, right?
Right. And again, I normally have 2 couples sitting around the table. I say there's an inspection process. The buyer has 15 days to do whatever inspections they like. They have 5 days to ask for either remediation, the broken widget to be fixed, or a credit, which has to be backed up for an estimate. So they have 15 days for their inspections. They have 5 days after that to ask for the remediation or a credit. The seller then has 10 days to respond. And the seller often will get their own inspector out there and see if the thing is really broken, if the estimate is really accurate, because you can get all sorts of estimates for certain repairs. And then the seller has the right to terminate or say yes or no.
That's right.
They don't have the right to terminate. They have the right to say yes, I'll do it, or no, I won't. If the seller says no, I will not fix that leaky roof, I will not fix that broken air conditioner, the buyer has 5 days to cancel and get their deposit back. So I go over the 15 days for the inspection, 5 days to ask your request, 10 days for the seller to respond, and then 5 days for the buyer to cancel. And then the points I hit are there's a limit to what the buyer can ask for. It has to be defined as defective, and I show them on page 5 where that's defined. Working condition, cosmetic, the seller doesn't have to do. So if you have a big deposit, the buyer can't get too aggressive on cosmetic issues.
Right.
If you have a $1,000 deposit, the buyer can get pretty aggressive on cosmetic issues. And then there's that one sentence that the cost to repair something cannot exceed its fair market value if it's working. So if you get a 10-year-old air conditioner, you really aren't entitled to a brand new air conditioner. So I try to get that broad parameter. If they're from up north, I talk them about mold. Let me see the mold report. I'll explain it to you. It's not as scary as you might think. And that's pretty much it with the inspections.
And what's the next one you got?
I got to paragraph 6, condominium and homeowners associations special assessments.
Wow.
I get a bazillion questions on that. I'm getting phone calls. I got one yesterday regarding a closing that happened 2 years ago, and a pipe burst. in the buyer's house. So does the seller have to tell the buyer that there might be a special assessment? Generally, no. You know, I mean, you read paragraph 6 and it says, you know, if it's not disclosed, the buyer pays for special assessments before the effective date of the contract. Between the effective date and the closing date, the buyer is responsible for up to 1% of the purchase price for special assessments that might be passed in that time period.
Okay.
Okay? If it's over the 1%, let's say you got a $300,000 closing, and the special assessment is right after the contract signed, and it's for $4,000.
Right.
So it's $1,000 over the 1%. The seller has the opportunity to pay the extra $1,000. If the seller says, no, I'm not going to pay the extra $1,000, you got a good deal, that's ridiculous, I'm not going to pay that extra $1,000, the buyer can cancel and get their money back. If it's after the closing, it's the buyer's problem. Now, where people get in trouble is if they're asked a direct question, they might say an untruth. You can't lie.
No, you can't.
Lying's bad. Lying's fraud. So if you don't know, you just say, I don't know. You know, I generally recommend just full disclosure. You know, if there's minutes from some meeting saying we're thinking about painting the building, we might have a special assessment, give them the minutes. You know, it's going to be an improvement to the property. It might enhance the value anyways. You know, but they're going to find out, give it to them.
Sooner or later.
Let's deal with it now rather than after the closing where the seller has lost all their leverage. So that one I hit a lot, and I'm still getting a lot of questions on that because of Irma, because they're still dealing with roofs.
And how about outstanding permits?
Outstanding permits, well, I tell them we do the permit search. It's something that was added in 2016. Not all permits are the same. You know, some are for 23-year-old sprinkler systems. Others are for in a pool enclosure that was done a year ago. So the pool enclosure obviously is more significant than the sprinklers from 23 years ago or the shutters from 19 years ago. So it's not a title issue. I think we hit on that on an earlier show. It's something that will show up when the buyer resells it. So if the buyer has plans on replacing the shutters or the pool enclosure, whatever, you know, they can disclose it to their next buyer. The buyer has the right to ask for the seller to close out these permits. And as part of the recent changes to the Naples contract, they expanded the definition of defective permits to include expired, void permits, you know, things that they might have thought of doing, but they just never signed the contract with the builder to do it, so they might not have actually done what the permit was pulled for. So the seller, you know, it's a defective item. The seller again has their 10 days to evaluate it. You know, is that person still in business? Did we actually do it? And they can say yes or no. And in many cases, they'll say no if it's something minor. But it's usually after we have a lot of conversation about, have you met the buyer? Did they seem excited about buying it? You know, do you think they'll break the deal because of this and walk away? Maybe they'll take a credit.
But you can still close. You can still close with an outstanding permit.
Do it all the time.
Right.
All the time.
Okay.
It's just
So
they're not all equally significant.
Right.
They just aren't. And with FAR-BAR, they're not a general repair item. That's the category in FAR-BAR.
Right.
It's just something that the buyer can extend closing date 5 days, and if the seller doesn't fix it, then the buyer can actually terminate in FAR-BAR. You know, Naples, it's a defective item that people negotiate.
Well, Don, I appreciate you coming on the show today, and I learned a lot.
Well,
This
is just how I do it, Jim.
Okay? So I think we do it about the same.
Okay.
You can't explain every detail, the 12 pages. That's why
People
we
can-
send it to
yeah.
them beforehand.
They can only absorb so much.
That's right.
You don't want to overwhelm them.
No, you don't. Well, thank you for tuning in today, and we'll talk to you next week. We'll see you next week. And that's
Thank you,
it.
Jim.
Yep.